Got it. All right, everybody. Welcome to a wonderful Monday afternoon. I know I'm a day off. I told you guys Tuesday. I lied. I was wrong. We're doing a Monday. Why? Because I'm not going to be here tomorrow. So I didn't want you to deprive you of me. I know how important it is to some people to see me and let me do my thing. So we're going to jump in today with a Q&A. I know you guys love the Q&As. And we plucked some really good questions. I found myself answering them, and I said these are such good questions that we should be discussing them, and that's what we're going to do. We're going to start off discussing some of the great questions that people have been posting in the comment sections on the videos, and I did answer a bunch of them, but I wanted to discuss them some more. And I see you guys already coming in with questions today. I will make sure I get to all of you, especially you, Victoria. You're always so sweet. So question number one, what if an independent judge sets a dollar amount on my case? Is that final? So independent judge, but the definition of the word judge denotes independence. A judge is an independent arbiter. And there was a question. I actually don't know if I made it one of the questions here, but there was a question: Is the WCB, the Workers' Compensation Board, on my side? Let's get the structure of who's who correct, so we can understand what I'm talking about. There's you, the injured worker. In New York, we call you the claimant. Okay, you are the claimant. It's the same as the plaintiff in a personal injury matter. You are the one bringing the action. For workers' comp purposes, you call the claimant. The insurance company is the carrier. They are the same as the defense. They're not the defendant per se. They're not the one that is your adverse party per se. I guess that would be like your employer, but they're representing your employer. And in certain circumstances, depending on how you're looking at the issue, they would be the defendant. But that's who that is. And just to open that up a little further, when there's an appeal pending, the person who files the appeal is the appellant. And the person who responds to the appeal, the person whose decision got appealed, the person who didn't want the appeal to be filed is the respondent. They're responding to the appeal. And who do we all report to? We report to the Workers' Compensation Board here in New York State. And that's where the judge sits. And the judge is independent. And the judge is the arbiter. And the judge is the Workers' Compensation Board is the tribunal. So they are supposed to be sitting and judging the case with an independent, open mind, and making a decision that they feel is the most reasonable, rational, objective, and honest that they can. So just to give you paint the picture of who's who in the world of workers' compensation, that's who we're dealing with. So an independent judge, all judges should and are independent. Now, and again, this also kind of leads us to the question about mediation and arbitration. Certain times in certain systems, there are mediators and arbiters. And I know in a third-party case, when you have a lawsuit, sometimes those go to mediation. But in the workers' comp world, the world that I live in and I discuss, mediation here in New York, we just had a case last week. Local 3, EESISP, the electricians union here in New York, they have their own system. They're self-insured and they have their own system and their own arbiters and mediators, and they are independent. And they're the ones that make the decisions on your case. So let's move on to the question part of your question. What if the judge sets a dollar amount on my case? Is that final? Well, it really depends on what dollar amount we're talking about. Are we talking about ongoing awards? Are we talking about settlement? Are we talking about the final permanent injury awards? And that's what I'm thinking you're leaning towards here. So when a judge makes a decision in a case, is it final? For all intents and purposes, yes, it's final. Can you appeal those decisions? Yes, you can appeal those decisions. Just had a conversation with Mr. XYZ. Our clients remain anonymous about the appeals process. This poor guy's case gets appealed. Every time we get a favorable decision, this insurance company appeals. This poor guy is just getting beaten around, and I feel for him. And if you're watching, my friend, I salute you, because you've been taking it on the chin, and we're trying to get through this. But yes, once the judge makes a decision, that is a final decision, but it is subject to appeal. That judge's decision is the law of your case. That is the law until something comes along to change it. And appeals, people fling around the term appeal all the time like it's, oh, the judge made a bad decision, just appeal it. Well, in order for an appeal to be valid, and effective enough to cause a change in a decision, whether it's a reversal or a modification or a rescission, to withdraw, to rescind that decision. An appeal must identify a mistake of fact or an error of law in that judge's decision, sufficient to justify a change, the change you're looking for. So just because the judge made a decision that you don't like, if his decision is based upon the facts correctly and properly applies the law and you just don't like the outcome, most likely you're not going to be successful. And that's really an unfortunate thing, because just because you're not happy with the decision doesn't mean it's the wrong decision, and it sucks, but that's just the way it is. So is it final? The judge's decision is the law of the case. It is subject to appeal. It could change, but for all intents and purposes, it is final. And each level of appeal that you move up the ladder, it becomes a little more restrictive as you go. Here in New York State, if you appeal a judge's decision, a workers' compensation law judge's decision, it goes to the board panel. The Workers' Compensation Board has a panel of commissioners. I forget how many are sitting right now. It kind of always changes because their terms come and go, and they come and go, and some, whatever. There's a bunch of commissioners up in Albany, and your first level of appeal goes to the board panel. So 3 commissioners hear that appeal and the appeal from the judge, and they make a decision. If one of those parties, if one of those commissioners dissents from the other 2, so if it's a 2-to-1 decision, you have the right to a mandatory full board review. Full board is the next level up. So you have the judge, then you have the board panel, 3 commissioners, then you have the full board. The full board review is when all of the commissioners hear your appeal, or at least hear your request for an appeal, and make a decision whether your appeal will be heard and what the decision will be on appeal. Full board review is only mandatory when there's a dissent at the board panel level. After that, they do have the right to deny review of an appeal. So it is harder to appeal a board panel review. That's why I'm saying each level you move up the ladder gets more and more difficult. Beyond that, you can also take your case out of the workers' compensation world when you move for full board review, and you can move into the state civil court sphere, the world of regular court, as they call it, and you can go to the 3rd Department Appellate Division and have them hear your workers' compensation appeal as well. Again, now you are talking about, you're rumbling with the big boys there. You have to perfect an appeal. There's a lot of rules and regulations that you need to follow to get that appeal heard, and you do need to identify mistake of fact or law in order to be successful. Simply because you don't like it doesn't mean it's going to be the grounds for review, reversal, rescission, modification. Great question, though. These all, by the way, every one of these questions, if I don't remember to do it, the reason why we are having this Q&A start off with these fantastic questions, these are all gold star level questions. You guys are in a class amongst yourself with the beauty of these questions. Next question. Judge gave me a 50% disability, but the insurer appealed. Waiting. What happens next? So this is the lead-in. What happens next? Well, a couple different things can happen. If the insurance company files an appeal, they have the right to stay, hold, not pay the portion of the decision that they're appealing. So, and this is why I chose this question here. If the insurance company is appealing the decision and says, we think that you're only entitled to a 25% disability, they are going to withhold half of what the judge ordered them to pay you and pay you the other half. So you will get something there. If the insurance company appeals and says, we don't think you're entitled to anything, you have no disability, well, they're going to hold all the money and not pay you anything until the appeal is decided. So, and it could be anywhere in that realm from 0 to 50% there. What happens next? Well, your attorney, this is why it's good to have an attorney who knows what they're doing, who can try to negotiate a resolution here. Your attorney might want to get on the phone with the insurance company and work out a settlement here. Hey, maybe they're not too far apart. Maybe the insurance company is looking for a 30%, your doctor, and you got a 50%. Maybe a 40% agreement is where you need to go here. 45%. You have the upper hand because here you from what I can see, what I'm assuming is that you are happy with the 50% disability finding because you didn't appeal it. The insurance company appealed it. So you have the case law in your favor. So you have a little bit of an upper hand here when it comes to negotiating with the insurance company. So now might be a good time to try to start or to push negotiations that have been happening here, try to get a settlement in place here, whether it's for a loss of wage earning capacity, ongoing awards. I don't know exactly what the 50% disability is referencing. Is it permanent disability or not? But all that said, it might be a good time to work a settlement out. So again, gold star question, and I do thank you for that one. But the process is like we just discussed when it comes to appeals. You got to wait for that board panel appeal to come back and then potentially full board review. Making moves always has good questions and comments. What happens if my company goes out of business while my case is still open? And I love this question. And we do get this question a lot. And I know, listen, I understand if I answer a question today, somebody might have the same question for me tomorrow, and I'm happy to answer. And I always tie this in with the other aspect of it. What if my company goes out of business? I always tie in with what happens if I get hurt the first minute of my first day on my brand new job for a brand new company? You are covered, provided that you work in a covered employment. You know, if you're a priest, clergy is not covered here in New York. If you're a New York City school teacher, I don't know the answer to the question because New York City school teachers are covered under their own system, FDNY, NYPD, things like that. But assuming you work in a covered employment, in a job that is otherwise covered under the New York State workers' compensation system, if your company goes out of business, but you got hurt while you were working for that company while they were in business, and even if you got hurt during the process of them going out of business, if it was a big going out of business sale and you got stampeded by the client, the customers running in to buy those last few items on closeout, you would still be covered. Just because a company goes out of business doesn't mean that you are prevented from getting your workers' compensation coverage. So you should still apply. Their insurance company, I'm assuming they had insurance while they were open, and the insurance company is responsible for those claims. If they didn't have insurance, well, it's a little bit tougher. You would still go through the Workers' Compensation Board and file an uninsured employer's claim. It does happen, and we deal with those cases as well here. In an uninsured employer situation, the board steps in and takes the place of the absent carrier. They do litigate those cases, and the state steps it up and picks up the slack in those cases. So just because your company goes out of business does not mean that you are SOL, as they say, shit out of luck. You are still in business. You are still in business, even though they're out of business. You could still file a claim, provided it is a claim that would otherwise fall within workers' compensation. Great question from a great contributor. Thank you. Another one. I love this one. We get this all the time. Do side jobs that pay cash weekly count for concurrent employment? So we 2 or 3 weeks ago, we talked about concurrent employment and how does concurrent employment work? Your rate of compensation, the amount of weekly benefit you're entitled to, is based directly on your salary. If you work at a job, let's think of a job here. People, help me out. You work for Target as a stock person. You earn $600 a week as you're a manager at Target. We like you. You're a manager at Target. You earn $600 a week and you get hurt. If you are totally disabled, you're entitled to 2/3 of your average weekly wage. If you're earning $600, 2/3 of that is $400. So for a period of total disability, you're going to get $400 per week. If you have a 50% disability, you get half of that, $200 per week. So what does concurrent employment mean? You are the manager at Target, and after you lock up for the night, you go and you work at a job. You're a bartender. You're a bartender. You're at the local watering hole, and we love it. And you earn $600 a week at that job as well. Okay, your concurrent employment now. If you were working at the same time, within that same time frame that the accident happened, you could apply and put in for concurrent employment benefits, where we take your average weekly wage from both jobs and we add them together. And what does that mean? Well, now your total disability from your $600 a week job just got doubled, because now you can prove that you're earning $1,200 a week, so you're entitled to $800 a week in workers' compensation benefits for a period of total disability. Now, when your second job is one that's on the books and you have pay stubs and you can get a letter from your employer and everything is on the up and up and it's documented, it's great. It's super easy. We submit the documentation and it's all there. What are they going to say? That you faked them? No, it's there. There's your pay stubs, there's your tax returns, there's a letter from your boss at your concurrent job, and you're good to go. If your second job, your side hustle is a cash job, it's a little more difficult. We need to prove that you were working at this job, and we have to prove what your earnings were. And like any job where there's a lot of cash, we're talking driving, Uber driving, Uber and Lyft now, it's all really credit card based. So the cash cab driving doesn't really exist like it used to, but it's still there. Car service, those dollar cabs, they're still getting a lot of cash. But bartending, any job, waitering and waiting, serving food at a restaurant where you're getting tips. Tips are very, very difficult because judges, they don't want to sit here and go through the back and forth of what a person earns in tips. If it's documented, we'll add it in, and if not, they usually give us a very difficult time. But at the law offices of Rex Sikowski, we still fight for that because it's entirely reasonable that a pizza delivery guy, a waiter or waitress, any tip-based employment, they have to factor in your tips. So it does still count towards your concurrent employment, but the burden now kind of shifts a little more to you because it's not as easy to prove your salary. What do we look for? Listen, we've proved concurrent employment, and we've proved average weekly wage in cases where somebody gets paid cash in an envelope every week, and we've gotten a copy. I don't have an envelope handy. A copy of the envelope. The person brought in a stack of envelopes that were ripped open with the money missing, and on the top it wrote Andy 600. And the week underneath, and we said, Judge, these are essentially his pay stub. This is what his boss gives him at this job every week to prove his earnings. It's a huge pain in the butt to bring in a whole stack of envelopes and to scan them and get them in. But listen, we'll do what we got to do to prove your concurrent employment. So if it's a cash job, off the books, things like that, it's a lot more difficult to prove what you were earning, but it's still a possibility. That all said, I was going to say something else, and I completely forgot what it was. Great job, Rex. Anyway, concurrent employment. Yes, it's still there for you. You got to prove it. I'll remember what I had to say, but I love that question. It's a gold star, 100% great question. Here, the comments are rolling. How long does my employer have to hold my job after the accident? Now, another great question. And these are the questions that I know I catch myself answering a lot are the ones that I like. And a little warm in here. I got to hit the AC. The Mets are on. Hope they win tonight. They need it. How long does my employer have to hold my job until after the accident? There's nothing in the New York State workers' compensation law that says that your job must remain open for X amount of time. The example I always give people, the workers' compensation law is here to protect your employer and the injured worker. It's not just here for the injured worker. I know I'm going to get a lot of flack either way on this one, but the law is written to protect everybody. And part of that is protecting the employer. And I always use the example of the Henry Ford assembly line. If you are the guy at the Ford assembly plant, I don't think there is one in New York, but let's just imagine there was, and it's your responsibility to put the left rear tire on every car that comes down the line, and you get hurt, and you're not there to put the left rear tire in every car that comes down the line, what is Mr. Ford and the Fordettes supposed to do? I'm not a huge Henry Ford fan. There's rumors that he was a raging anti-Semite, and that's not cool. But whatever. I'm using the example anyway because he did invent the assembly line, and I got to give him credit where credit's due. Anyway, I digress. If you're not there to put the left rear tire on every car that comes down the line, what are they supposed to do? Shut down the factory until your broken pinky gets better? No, they can't suspend their business because a worker got injured. Workers' compensation is there to help the worker, but they have a right to replace them, whether it's temporary or permanent, and move on with their job and their company and their duties. So there's nothing in the law that necessarily says that your job has to stay open. Federally, things might be different. I don't know the answer to the question under the federal laws and FMLA and things like that. But generally speaking, here in New York, they do have a right. They cannot fire, and this is where discrimination comes into play. They cannot fire you for filing for workers' compensation, but they can replace you to get their job done. And that's where that gray area comes in when somebody claims, hey, they didn't hold my job, they got rid of me, and they brought somebody else in, and he works cheaper, and blah, 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 blah. And then we start having big fights about whether you have a valid workers' comp discrimination claim or not. Workers' compensation does handle discrimination actions if you are fired or discriminated against for filing for or participating in a workers' compensation case. So that goes hand in hand with that question. There's 3 more questions here. I'm going to knock them out quick, and then we'll get into your questions that you're hitting me with. Can I apply for paid leave while I'm getting paid from workers' compensation? So we always get a lot of questions. Can I apply for unemployment? Can I apply for Social Security disability? Can I apply for New York State disability? Can I apply for food stamps? Can I apply for all sorts of different programs? I'm going to tell you this. I handle workers' compensation only. I don't know the ins and outs of the disability laws and Social Security disability and FMLA and things like that. And you can apply for benefits under other programs. The one thing I'm just going to tell you, always be upfront and honest. Don't lie on your applications. Don't lie to anybody you're talking to when trying to get these benefits, because not only is it going to screw you there, it's going to screw you here, and it stays with you forever. I was going to use whatever. It stays with you for a long time because you lied. Don't say that you didn't get hurt on the job to try to get benefits from a different source when you did get hurt on the job. Don't say that you're totally disabled on one hand and you're partially disabled on the other hand so that you get benefits. It's just not good, and it's just not worth the money, because ultimately, if you're found to have committed fraud in any of these areas, it's a big deal, and you don't want to have to deal with that. Get your benefits that you can, be upfront and honest, get through, and move on with your life. Lala Travel, I like that handle on there. Lala Travel, we call our daughter Lala sometimes. Is it a good idea to have the same lawyer for workers' comp and third party? Well, it's not a bad idea, but it's not always an option. I don't handle third party claims, but I am the next best thing to having the same attorney, because we work closely with most of the lawyers that handle the third-party claims. Do we work closely with all of them? No. You're entitled to get any lawyer you want for your comp and any lawyer you want for your third party. But it's always good. I enjoy working with a lot of these attorneys that handle third-party cases for a lot of different reasons. Number one, when it comes time, when that case is kind of coming to a point and it's time for settlement, whether it's my case or their case, we sit down, we hammer out the details, and we try to figure out the best way to get the most money for you, whether it's settling the comp first, settling the third party first, settling them simultaneously in a global settlement, not settling, proceeding with treatment or surgery. Every case is its own little animal, and having everybody on the same page and with open communication. The lawyers I deal with have my cell phone number. I have had conversations while they're on vacation sitting on a beach about how to settle a case and vice versa. And I have no problem. I've had conversations at 10, 11, 12 o'clock at night about settling a case and what needs to be done and what we're looking for to get this client the best deal possible. And that's how we are. These are great guys and girls, and we all work together, and we love talking to each other, and it produces a great outcome. The one thing that I do also like is it gives me, as an independent attorney, a sounding board against another attorney, which is something you kind of lose when there's one lawyer handling both. Sometimes a tricky situation comes my way or comes their way. Sometimes something, whether it's me, I learn and I do well when I can speak and hear myself explain what I'm looking for and what I'm looking to do. And that just gives us that sounding board. So I'll call so-and-so attorney at 10 o'clock at night while whatever and say, look, this is what I'm thinking about this case, and da-da-da-da-da, and I'm thinking this, and I'm going to take this route, and I want to do this. And they say, great idea. Or they say, did you consider this as well? And it gives you that opportunity to have that second brain on a case. I see Catherine is gesturing wildly. The Mets scored a run. Now you messed up the whole video, Catherine and Mark Vientos. So that's one thing that you do lose when it's just one lawyer. And there's very few. You might have a lot of firms that do both. There's actually not even a lot of there's a couple that do both, but very, very rare you have one lawyer handling the comp and the third party. So at least here in New York, I like having the opportunity to call these attorneys and just these are all smart people, and you lose that when one person's handling everything. Sometimes you fall down the rabbit hole of a case, and you got to be able to kind of think things out and think things through, and having that second person or third person there to hear you out Very, very helpful. Is it a good idea? Is it legal? Wait a minute. My notes and my. Is it legal to get a second? Did I skip a slide? No, I didn't. Okay. Is it legal to get a second opinion from another attorney regarding my case? So Stendhal, who always asks a bunch of questions, very good questions, good contributor, asked this question. The question that he actually asked in the comments was, is it a good idea to get a second opinion from a lawyer, like getting a second opinion from a doctor? It is, and it's yes. Is it legal? Certainly legal. If you want to get a second opinion, the problem is getting an attorney also to do. Listen, as lawyers, we're running a business as well. And sometimes when a case comes along that's a couple years old and most of the work's been done and you just want an opinion on value, it's kind of hard. I don't know your case. I don't know what's happened in the last 3 years in your case. And I can't just say, yeah, that's a good deal or that's a bad deal. You really need to know what's going on with the case. And then the next step is, do I really want to substitute an attorney who I know did a decent job on that case just because you want that second opinion and the potential to get a few more dollars, maybe? It's not. I don't like doing that. I don't like taking work away from other people just because I have the chance to do that. Only when I think that the person that didn't, there's a chance that you could do a much better job or you could save something from peril. Do you really want to substitute a case? Some clients come in and say, look, I hate my existing lawyer and I'm going to substitute this case no matter what. And okay, fine. Well, let's talk a little bit. But generally speaking, getting an opinion from a lawyer is a little different than getting an opinion from a doctor. But is it legal? Yes, it's legal. And if that's what you want to do, go for it. So let's dive into some of your delightful questions, comments, and 1-0 Mets. Victoria makes me smile. Can't wait for the live. You always give great information. Thank you so much. That's very sweet. And as always, folks, if you like what you hear, if you like what I'm telling you, I get so many great comments on the in the comment sections about how I've helped you get through a tough time in your life. And listen, that's what we're trying to do here. We're just trying to help you get through it, give you a little information, put a little ammo in your guns moving forward against the big bad insurance company, and maybe put a smile on your face. And that's what we're here for. If you like what I'm telling you, if you're happy with how things go with us, please hit the like button, subscribe. It makes me feel good. I know I'm not always great when I tell you I'll be here on a Tuesday and I show up on a Monday. I know sometimes I go away and I miss you guys for a week or two. I miss you when I'm not here. But hit the like button, subscribe, give me the fuel to keep going. There, we got a thumbs up. I got a second job and was injured, but my second job pays cash every week through Zelle. Will I be able to use the income towards my average weekly wage? Now, you just threw a little caveat into our earlier question. Zelle, now there is a trail, a paper trail, an e-trail of these payments that you've been getting. And if that Zelle shows that Mike's hardware store has been paying you $400 every week for the last 6 months, that's good evidence to me. So that does help. And yes, you could. Now, again, we have to make sure that your second job is covered employment. The real question that you need to think of here is, if I got hurt at my second job, would I be covered under workers' compensation? If the answer is yes, I would also be covered there if I got hurt, then that concurrent employment sticks. If your second job, we've seen it as a mailman, well, the United States Postal Service is federal workers' comp, doesn't fall under New York State, so you can't use that as concurrent employment. But if it's a job that would fall under the protection of New York State workers' compensation, if you got hurt there independently, then yes, concurrent employment would stick and you should use it. So Central Coast 831, yes, to answer your question. If you're in New York and you need help with that, you give me a call, 212-406-8989, my first shameless plug of the afternoon. Berserk. Hi, Rex. Workers' comp doc claimed MMI and refuses any more treatment because I am afraid of the surgery. Low back. Lawyer says I am still not allowed to see my doc or any doc for that matter. What gives in New Jersey? That's weird. Okay, I need to reprogram my brain. You're in New Jersey. New Jersey, from what I understand, they do the insurance company sends you to their doctor for an initial period of time. I don't know how long it is, and you treat with their doctor before you can try to go to your own doctor. I don't know the answer to your question. Do you have a lawyer? in New Jersey. I don't do New Jersey cases. I have a good buddy who does, and he's fantastic. Every client I send to him is like, they love this guy. They think, and he makes me look bad. That's how good he is. I hope you have a lawyer. If you don't, you want to give me a call, I can get you hooked up. 212-406-8989. I don't know the answer to your question. The questions we get from people that are in California and New Jersey and Connecticut and Arkansas, and we got a bunch from Louisiana early on. I don't know the answer. I'm a New York guy. I'm sorry. I know. Josh Gardner, Ben Gardner's brother. It's Ben Gardner's boat. Can I end a case whenever I want and still get a settlement? Theoretically, yes. Theoretically, if you're a week into an injury and you say, I don't want to ever go to the doctor, I don't care anymore, and you call the insurance company, you say, look, I know I have a huge case here. I've broken arms and blah, 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 blah. Give me 10 grand and I'll go away. It theoretically can happen. So yes, you could settle. Settlements are voluntary. If you get the carrier on board and everyone wants to settle, go ahead and settle the case. So in theory, that's yes, you could always try to settle your case. So Berserk would be my third surgery, by the way. Only allows so many. YouTube only allows so many characters. I'm one of them. Again, I don't know the answer to the question only because it's a different jurisdiction. But give me a call and I'll try to get you set up with somebody if you don't already have a lawyer. Oh, it's water time. It's either peanut butter jelly time or water break time. Sorry, I'm slurping right into the microphone. What a piece of trash I am. All right. So Josh Gardner was just asking, can I end my case whenever I want and still get a settlement? Surgery was approved, but I denied it. I want to go a different route. Will I be able to end my case and still get a settlement? Most lawyers won't pick up my case here in Tennessee unless I do the surgery. Surgery adds value. You could, you could call the carrier theoretically. Again, I don't, like I just said, I certainly have never handled a Tennessee case. I do love the great state of Tennessee. Been there many times. Well, I've been there a few times, and it's fantastic. You could call the carrier and try to work out a settlement on your own, but you got to be careful because, if you're thinking, well, I'm going to settle my case and take the money and go and get a different type of treatment, let Medicare pick it up, you might have a problem with Medicare. If I might try to put it through my private health insurance, you might have a problem with them. If you try to pay for it on your own, you don't know how much it's really going to cost, and if there's, God forbid, any negative repercussions following a significant treatment, you don't know what that's going to cost. Be careful. Be careful. Be careful. I know, some lawyers don't want to touch a case until it shows that there's value. I'm not one of those guys. I like to help everybody to my own detriment. But maybe it's worth having a consultation with somebody and telling them what you're planning on doing. If they see it might be a quick settlement, it might be something that could entice them to help you out. I wish you luck with that. Duke. My dog's name was Duke. I miss him. Hi, Rex. I have a meeting with an ALJ to discontinue my workers' comp after 18 months, and I have reached MMI from an insurance doc, so this is a hint they want to settle. I don't understand when you say discontinue. Could they come up with a figure at the meeting? Yes, they could. If you have a lawyer and you're ready to be done with this, maybe you want to ask your lawyer to come up with a figure and start wrapping this thing up. I see some questions popping up on the gram. Just bear with me. But Duke, thank you for the question. Machine Inc. This is going to be an ethical and professional question. I have the same lawyer, workers' comp, third-party case. Can my lawyer attempt to do something fishy behind closed doors with the defense lawyers? Can they? Yes. Does it happen? Those. I'm not even going to call it an allegation because they fluctuate from outright allegations to hints of nefarious conduct. They happen more. People talk because they can. It's such a rarity. It's such a rarity. Your lawyer has an ethical, legal obligation to you and you first and foremost. And if you think things are going in a way that they shouldn't be, talk to your lawyer. And I hate to say consult with another attorney, but maybe you need to consult with another attorney. But it really should not be happening. And it happens people love it. Happens probably 2-3 times a week when somebody comes in here and says, this is bullshit and my case was worth more. And the insurance company is paying off the judge. Well, I know that you're pissed, and no, they're not paying off the judge. And or this one, they're in bed together, or this is that, and that's it's. I've never seen it happen. I know we hear stories, and it's juicy fodder and makes for great television movies, but it doesn't happen. It happens very rarely. How about that? One Hot Records. I understand you don't want to rub certain insurance companies the wrong way, but how about Crum and Foster? Are they appeal happy? Have a water. I really need to read these questions before I post them. But VA Murph, my employer, not any more so than anybody else. How about that? My employer insurance lawyer asked, did we want to settle? So my lawyer made a demand for a certain amount in February. Good. They never responded, so now I have a mediation date coming up. Their doctor, off Pavel, cleared me to go back to work, but physical therapist said there's no way I could possibly do my job. Are they trying to lowball me? What if I don't accept what they offer? Well, they're always going to try to lowball you. The insurance companies are always going to try to save themselves money by paying you less than your case is worth, at least initially. So yes, maybe they are trying to lowball you. What would happen if you don't accept their offer? I don't know. I don't know what jurisdiction you're in. I don't know. That's panel, by the way. Not Pavel. So I don't know. They could just say, damn it, that was what we thought our best offer would be, and now we're taking off the table and we're going to fight you all the way. Or they could turn around and say, let's negotiate. I don't know, but they could certainly be a lowball offer, and maybe it's the opening of a negotiation that's fruitful and gets you the results that you're looking for. You clarified here. The doctor off panel cleared me back full duty, but therapist said there's no way I can perform old job tasks. They're trying to lowball me. What if I don't want to accept it? Talk to your lawyer. That's really what you want to do. That's what you want to do, is talk to your lawyer, get on the same page, start working towards negotiating a resolution. Callahan, Big Tom Callahan's son, who had a bunch of great questions last week. Thanks for joining, my bud. This guy's just a retired UPS guy. Is it normal for an attorney to hold the psychological report from the injured worker? If so, why? I don't. Are we talking about is that an independent or a state psych eval? I don't understand. If the primary doctor puts in MMI, can the psychologist doctor still keep you out? Here in New York, yes. They're different injuries. If you had a busted knee and a bad back in the same accident, your knee doctor could say, hey, your surgery was great and your physical therapy went great, and as far as we're concerned, your knee is all better. You can go back to work. And then your back doctor can say, not with that back. Same goes for a psych when you have a psych and a physical injury. Callahan, Big Tom Callahan's son, Workers' Compensation Board will not process the Section 32 unless additional information. What type of information they need? My lawyer said everything is okay. I'm confused. Thanks for the clear answer. So we got one of these today. If this is a New York State case, if you file workers' comp in New York, everything is form and paper driven, and they have a form for everything. If you file your Section 32 papers and you get a C32.4 in the mail, that's a notice from the board saying, we got your papers, something's wrong. Or maybe something's wrong, or we think something's wrong. 2-0 Mets. The one today, you didn't address outstanding C8.1. So what's a C8.1 here in New York State? A C8.1 is when an insurance company wants to object to a doctor's bill. They file a C8.1 objection. And when we Section 32 a case, we're supposed to address all outstanding C8.1s. And we got a notice today saying, hey, on this case, you didn't address 8.1s. And usually the carrier drafted the papers and they missed it, and I must have missed it in my review, but I thought that all 8.1s were actually resolved. But it's something along those lines. Maybe somebody missed a signature on a signature line. Maybe the numbers don't always add up, especially when you get, when you have a $50,000 settlement with when you have clean numbers that end in 00, the numbers line up. But when you have MSAs and annuities and things like that, the numbers sometimes get down to the pennies, and if you're off a penny here or a penny there, the Workers' Compensation Board will kick that back until all the math is perfect. So could be anything like that, and it might not be that big a deal. Sometimes the board punts things back to us and says that there's a problem, and there's no problem. And then we got to, and unfortunately, I almost wish there was a problem, because it's quicker and easier to fix the stupid problem and say, here, your problem's fixed, than to get them to agree that there was no problem to begin with and to move the case forward. And hopefully that's, I don't want to say hopefully that is the answer or not, because that means there is or is not a problem with your case, but that's just the way it is, unfortunately. But that's why you have a lawyer, and that's why everyone's here to make sure everything goes properly. Now you guys are just laughing at me. Vic, Mr. X, what if someone that is on comp gets to a car accident? Should they let the doctor and lawyer aware of the incident? Yeah, please. We need to know what's going on. We need to know what's going on. And I can't tell you, I'm not going to use that long. I can't tell you how many times, but it happens where we're sitting there and they're like, by the way, I had a car accident 2 months ago. When were you going to tell me? I didn't think it was, I didn't think it mattered. No, it matters. Please let us know what's going on. You should absolutely tell your lawyer. Absolutely tell your lawyer. Explain the whole thing. This, maybe it's not going to make a difference, but talk to your lawyer about it. This is the kind of gold star comments that we love around here. Let's go Mets. They really lost 2 heartbreakers in the last 2 days, but hey, last 3 days, those 2 to the Nats. The Nats are not a bad team. The Nats are not a bad team. They got nothing to lose, and they play hard. Is it legal to ask for a second opinion from lawyers, same what we do with doctors? So that's the question that we had before. Yes, you can ask for a second opinion. Berserk, at Callahan, you'll be one of the luckiest if you could. I still haven't been treated for over a year, and the lawyer says I'm out of the blue. I'm still now allowed to see my FOC, yet workers' comp doc won't treat me. I think he went for DOC. He claimed MMI. You guys chat. If current salary is higher than previous salary, can affect the Section 32 of my settlement. Thanks again. Yeah. If you go back to work and you're earning more money than you were before your accident, there's no reduced earnings. So then these are all the videos we talk about: schedule loss and non-schedule loss, reduced earnings and non-reduced earnings. So that's where all that comes into play. Mr. Marte, after 6 years and 2 weeks left for my trial, good ideas to change lawyers? We spoke about this, my friend. I know Mr. Marte and I had a nice conversation a few weeks ago. 2 weeks left. You have your trials in 2 weeks. We spoke about this like a month ago, 3 weeks ago. Be careful. I don't want to. I hate seeing you guys get hurt. Oh, Callahan is live. Stendhal is virtual. You have alter egos, my friend. Big Tom Callahan's son is Stendhal. You have no idea what I'm talking about every time I say Big Tom Callahan's son. It's from Tommy Boy. Great movie. William, Guillermo, I have come to MMI in a major case that put me on SSDI. I also have a third-party case. I have lots of options. Tell me some things I need to look for. Love, happiness. What do you want to look for? Do you have a lawyer? I'm assuming you have a workers' comp, Social Security attorney, personal injury attorney. These things take time. Go get your. I always tell people in this circumstance, look, you have a lot going on. You have lawyers up the wazoo. You have all this. Your whole life just got flipped and turned upside down, like the Fresh Prince of Bel-Air. What you need to do is focus on going to your doctor, getting your treatment, getting yourself better, getting yourself to as good as you can get. Because if you don't do that, if you drag your ass going to the doctor and it doesn't seem like you're doing what you can to make yourself better, they're gonna exploit that on your third party case, especially. They're gonna say, this guy is supposed to go to physical therapy 3 times a week. He hasn't gone in 2 months. He's not trying to make it. He's not mitigating his damage. He's not doing what he can to get better. And so put all the crap aside. Go to your doctor. Get yourself better. Do the best you can. Berserk is 150 years into this, 1.5 years deep into this. And listen, 1.5 years is not always a long time. It's unfortunate with some of these cases. It sucks. The system is here to help you the best you can, the best it can. One Hot Records. Hey, Rex, I hear on all your vids that you can refer us to other attorneys if we're not in your state. How about employment attorneys? Do you have referrals in your network for those attorneys? Some out of state, some. If you need help, call me. Listen, what's the worst that I'm going to tell you? I can't help you. I don't know anybody. Call me and I'll see if I can help you out. I do know a bunch of employment attorneys here in New York State that can help you out, but outside the state, it's a little more difficult. I usually have to call my friends, I don't know why I keep saying everything's little today. My contacts out in other states and see if they know anybody. If it's a federal issue, then a New York State attorney might be able to help you out. But give me a call. What's the worst that'll happen? I don't know. I'm gonna do everything I can to help everybody. So I always do. I have a case in 2021, and the judge decided I have a 50% disability, but the insurance company appealed the judge's decision. I think I took your question earlier. Let's check that out. I think I took your question. No, that was somebody else. Well, it's the same answer. The insurance company appealed the decision. What do I think will happen? Well, you will have the upper hand here because the judge ruled in your favor, and the insurance company appealed that decision, which obviously you liked because you didn't appeal it. It's a good opportunity if the time is right for you to potentially settle your case. So you might want to talk to your lawyer about maybe working out a settlement. Could be a good time for that. Otherwise, make sure your lawyer knows, draft the rebuttal, submit it, and you got to wait for a decision there. But at least you got the upper hand and the judge ruled in your favor. Psy, who is still coveting his gold star from last week, he was actually writing a speech, acceptance speech, and he loved the gold star that we got him. Makes a very good comment here. Don't forget to like the video if you find it valuable. Don't forget to subscribe if you want to hear and see more of my ugly face. And please, if you have any questions, my number is scrolling across the bottom of the YouTube. It's not there on the gram. 212-406-8989. Always feel free to give us a call. We'll do what we can. Cynthia Moore has a 17% rating on a foot. How much do you think my case is worth? It is worth a little bit more than a 16% of a foot, slightly less than the 18. I don't know what your average weekly wage is, Cynthia. I don't know what you were previously paid. I'm assuming this is in New York. It's hard to say, but I will tell you this. Based upon my mathematology, if you are in New York State and you have a 17% schedule loss of use of the foot, that is worth 34.85 weeks. Yes, folks, let me double check that. You are baffled by how fast I could say 34.85 weeks of compensation for a 17% of a foot. Again, that might be what your doctor's saying. I don't know what the insurance company's doctor is going to say. Is that what the final agreement or decision was? So there's still some variables. What's the case worth? It's worth 34.85 weeks of compensation minus any prior payments, generally speaking. It's hard for me to get any more specific than that without knowing the intricacies and specifics of your case. But great question. Natalie, hi Rex, my comp. Hi Natalie, my comp. All depositions and summations are taken. How long does it take for a judge to review and make a decision? Will a hearing be scheduled? Thank you. You might be waiting for a hearing. You might have a reserved decision. It could go a couple different routes here. But it's usually within a few weeks after everything's been finalized. A couple more here, folks, and then we're going to wrap it up. Cynthia Moore, my employer did not have insurance, so I had to go to work. Will they take longer time or short time to set up my case? I'm not understanding that question, Cynthia. Call me, 212-406-8989. Is it possible to file workers' comp for depression caused by workplace bullying for managers? Yes. Psychological claims. We did a video on it. I think we posted some of those videos. You can file a psychological claim. So the answer is yes. They are difficult. The insurance company is going to fight you. So just keep that in mind. Gustavo, why some lawyers do not take serious and willful misconduct? I don't understand the question. But Dwayne, I've been in workers' comp for 3 years. 2 fusions, 1 cervical, 1 lump, also knee surgery, partial meniscus removal in cartilage. Insurance is a lowball offer. What should I do? Fight them back. What you should do, talk to your lawyer, figure out where the value is in that case, and go back to them if you're interested in settling. And if you're not, if you need more surgery or treatment, There's nothing wrong with saying, hey, I don't want to settle right now. I'm gonna get my other knee surgery or whatever it is you need. If I'm hurt at work due to an appliance malfunction, such as an elevator malfunction, but the company employs a third party to maintain it, am I barred for pursuing said company from liability? No. There are certain aspects depending if there's general special employment or things like that. But generally speaking, if it's a third party, then you can pursue a third party liability action against them. If you have an attorney, you should talk to them about that. If you don't, call me. Let's go over the facts and I'll tell you what I think. 212-406-8989. It's a very good question, and you might have that opportunity to do that. Folks, I know there's a couple more questions flowing in here, but I do have to wrap it up. And next week, let's go check out the calendar. Let's check out the calendar. Hopefully, I will be. What is that? What is this, folks? I have a dinner there. I like dinner. I'm hungry. Psy, my guy, 4 p.m. on May 7th. 4 p.m. on May 7th, Wednesday, May 7th, 4 p.m. Put it in your calendars. Write it down. Set a reminder. All y'all, even Gypsy Weber Wright. Good day. I'm assuming you're Australian. My accident was 18 months ago. I had surgery on February 6th. 13 months later, my case feels like it's dragging on. How long for a judge to determine disability? Usually here in the workers' compensation world in New York State, you're looking at a year from your accident date, or I'm typing in YouTube live. It's a year. Usually it's a year is the minimum. They want you to. She's an Aussie. They want you to get as good as you can get, and before they start assessing you for permanent disability. Oi. Thank you so much, folks. It's been great, and I love you all. Any questions, give us a call, 212-406-8989. Let's go Mets, and let's go Australia, and we love all you guys. We'll see you next week on the 7th, 4 p.m. Have a great day. Bye-bye.